Welcome to part 2 of the lecture. So we spent quite a bit of time talking about the minimum degree of care, all of those elements that constitute the minimum degree of care. Now we're going to move into the New York State definition of neglect. What is a neglected child in New York State? And here's the law. A parent or any other person who's legally responsible for a child must provide them with the minimum degree of care. We talked about that quite a bit in part 1. If a parent or a person who is otherwise legally responsible for a child does not provide the minimum degree of care, and that failure results in harm or imminent harm to the child's physical, mental, or emotional condition, then that child has been neglected. And the harm or imminent danger of harm, it must be actual harm to the child's physical, mental, or emotional condition, or the child's physical, mental, or emotional condition must be placed at immediate danger of harm. Now that's a whole lot to take in, so we're going to break it down in a couple different ways. First, harm or imminent danger of harm. To be neglected, a child's mental or emotional or physical condition must be harmed or put in imminent danger of harm for that child to be neglected. Actual harm is not required, but if you're going to use the part that says the child's condition was put at imminent danger of harm, it's very important to mean imminent means immediate, right now, in the next few minutes. It doesn't mean future harm. So if a parent's doing something that could be dangerous to the child in the future, that child is not neglected. The child must be actually harmed or put at imminent or immediate risk of harm. Very important to remember that. So what is imminent or immediate harm? A parent is threatening to punch a child in the face. Is that imminent or immediate harm? Yes, it's imminent harm because a parent is standing in front of a child right here and right now, threatening to punch a child in the face. So that child's physical condition is at imminent risk of harm. What about a parent who says, one of these days I'm going to kill you? Is that imminent harm? No, because a threat of future harm is not immediate. It's not imminent. It's right now. So a parent threatening to harm a child in the future is not neglect. How about a parent is so intoxicated that he or she cannot wake up to care for the child? Is that imminent harm? Yes, a child whose parent in the household and the only adult in the household is so intoxicated that he can't wake up to care for the child, that child is at imminent risk of harm because that parent's intoxicated. That parent can't respond to an emergency or respond to the child's immediate needs. So therefore, the parent's intoxication has caused the child to be neglected because their physical, emotional, or mental condition is at immediate risk of harm. How about this one? Parents are screaming at each other while the infant is upstairs sound asleep. What do you think about that one? The parents are screaming at each other, they're verbally fighting, and the infant is upstairs asleep. Is the child's mental, physical, or emotional condition at imminent risk of harm? No, it actually isn't. This would not be neglect because the child is sound asleep upstairs. So if a child is able to sleep through an argument, even a violent argument, this would not be neglect because the child's sound asleep upstairs. So their mental, emotional, or physical condition is not at imminent risk of harm. How about this one? The parents are screaming and pushing each other while the child is in the room. is that child's mental, physical, or emotional condition at risk of immediate harm? Yeah, it is, because the kids present in the room when the parents are not only screaming and being verbally abusive to one another, they're physically pushing each other. So that child's emotional condition is at imminent risk of harm, and their physical condition is at imminent risk of harm. It's very unsafe for a child to be in a room where two adults are screaming and pushing each other. So a child who's sound asleep upstairs during an argument, even a violent argument, is not neglected under New York state law. However, if a child is present while parents are screaming and pushing each other, that child could be considered neglected under New York state harm because they were put at imminent risk of harm. Of course, our entire class isn't just about child abuse and neglect, right? It's about family violence. So when we talk about neglect and domestic violence, when parents or people who are otherwise responsible for children are engaging in domestic violence, is that neglect? And the answer is, it depends. As we just saw from the previous example, if a child sleeps through a violent argument and has no knowledge of it, then that child has not been neglected. It doesn't mean that that's a good way to parent children, or that's what we want to have in any home where a child is present, but it doesn't meet the New York State definition of neglect. But exposing a child to domestic violence can meet the definition of child neglect when the exposure harms them, of course, if they're physically harmed, mentally harmed, or emotionally harmed, or if the parent's conduct puts that child at imminent danger of such harm. For example, if the adult who's violent creates an immediately dangerous environment, if children are present and they're terrified, if a child is intervening and trying to get parents or a parent to stop fighting, that's a very dangerous situation for a child to be in. If adults are throwing objects or physically fighting and children are in the room or nearby, that could constitute neglect because those children are at imminent risk of harm. If a child is experiencing depression, anxiety, or other psychological issues due to the exposure to violence, that is certainly neglect. That is actual harm. That child has been harmed emotionally because they're witnessing the domestic violence has actually caused them to be depressed or anxious or to suffer other psychological issues. That would constitute neglect. If police are called to the home and children are present, that can be neglect depending on the circumstance. If the police are having to intervene in a violent incident and the children are present, that can certainly be cause for a neglect charge. So it's critically important that you fully understand the New York State definition of child neglect. So if you have any questions about this, I really want you to ask me. I am happy to answer any questions you have about this. And just to go over our definition again, a parent or person otherwise legally responsible for a child in New York State must provide them with the minimum degree of care. That is the legal standard, the minimum degree of care. If a parent or person otherwise legally responsible for a child does not provide the minimum degree of care, and that failure to provide that minimum degree of care results in the child being harmed or being put at imminent risk of harm to the child's physical, mental, or emotional condition, then that child has been neglected. And remember, if there's not actual harm, then there needs to be imminent danger of harm. Imminent means immediate. So the child needs to be either actually harmed for it to constitute neglect, or their physical, mental, or emotional condition must be placed at imminent danger of such harm. Let's do some examples of neglect. Maria does not have enough food to eat, and she's hungry all the time. Maria steals food from other children in school, and she's underweight. The parent has been offered public benefits to obtain food, but refuses to accept help. Is this neglect? Yes, it is, because the minimum degree of care requires that Maria's parent provide her with adequate food. If she's not being provided adequate food and the parent is offered public benefits but refuses to accept help, then that is neglect. That is a failure to provide food to the child, and the child is harmed because she's underweight. So that would constitute neglect. Let's look at this one. Terry arrives at school in shorts and a t-shirt in cold weather. Terry is often very dirty and has a serious body odor. Other children will not sit next to him in school because his body odor is so bad and his hygiene is terrible. Teachers is offered to give the child clothing, but the parents refuse to accept it. The parents insist the child is just fine and does not need any additional clothing or help. Is this child neglect? Yes, it is. Part of the minimum degree of care is that Terry has to be provided with adequate clothing. He must have adequate clothing for our weather, right? And if it's very cold weather and all he has are shorts or t-shirts, he does not have adequate clothing. The child also in this situation has a serious hygiene issue, which is part of the minimum degree of care. How has the child been harmed? Well, his hygiene is causing him problems in school because it's so bad the other children won't sit next to him. And the parents here have been offered help but have refused. Therefore, Terry is a neglected child under New York state law. Here's another one. Kristen and David are children who live in a filthy house. It is full of rotting garbage and there is animal feces and vermin throughout the house. There are large holes in the ceiling and their parents are using the oven to heat the home. Are Kristen and David neglected children? Yes, they are. Part of the minimum degree of care is adequate shelter. Now, as we discussed in part 1, shelter does not have to be beautiful, does not have to be a lovely modern home with all of the conveniences. It doesn't even have to smell good or look nice. But this condition has gone far beyond that. When children are living in a house that's full of rotting garbage and animal feces, that is definitely inadequate shelter under the law. Having large holes in the ceilings and the parents using the oven to heat the home creates a very dangerous environment for the children. So in this case, Kristen and David are neglected. Let's look at another one. Dan is 8 years old and has not been to the dentist in several years. He is constantly complaining of pain in his mouth, and it is apparent he needs serious dental work. When told Dan must be taken to the dentist, his father responds that he never went to the dentist and Dan doesn't need to go either. Is this neglect? Yes, it is. Part of the minimum degree of care is adequate medical care. Medical care includes dental care. It could also include mental health or psychological care. In this case, the young child, Dan, who's only 8, has not been to the dentist in several years. He has had actual harm, right? This is actual physical harm. He has a lot of pain in his mouth and he needs serious dental work. So in this case, the child, Dan, has been neglected because he has not been given adequate medical care, and the result of that is his physical condition has been harmed. Tammy is in the 9th grade and has had 36 unexcused absences in the past 3 months. She is failing 3 classes as a direct result of her chronic absenteeism. The school has tried to reach the parents by phone, text, email, and letter, but the parents do not respond to the school. Is this neglect? Yes, it is. Kids miss school. A lot of kids miss quite a bit of school for a variety of reasons. But Tammy, being in the 9th grade and missing 36 days of school in just 3 months is absolutely excessive. And the reason it's neglect is because part of the minimum degree of care is that parents must provide for the children's education. What is the harm? Well, her chronic absenteeism has directly impacted her performance in school in that she is failing 3 classes. And that the school has tried to work with the parents and reach them, but the parents aren't even trying to respond or work with the school in any way. So this would absolutely mean that Tammy is neglected. A Spectrum Cable employee was walking past an apartment when he heard a child crying. He knocked on the door and a child about 5 years old opened the door and let him in the apartment. There were no adults in the home and the child was crying and upset. The child asked the Spectrum employee to make him something to eat and to watch a video with him. The Spectrum employee waited in the home for 10 minutes and when no adult arrived, he called the police. Is this neglect? Yes, it is absolutely neglect. Part of the minimum degree of care is adequate supervision. And although there may be younger children who are perfectly capable of being left alone in a home for, an hour or so, a 5-year-old is definitely not able to be left home alone for any period of time. This child was put in a very dangerous situation when he opened the door and let a stranger into his home and started communicating with him. The results of this could have been disastrous. And unfortunately, this is a common call to our hotline. Oftentimes when we find out children who've been left alone, it is because someone from a utility company, the cable company, has found a very young child left home unsupervised. So how has this child been harmed? Well, although there's been no actual harm, the child has put at imminent risk of harm. If the child had been caught in a fire in the home or another dangerous situation, a 5-year-old is not mature enough to know how to handle that safely and correctly, and the child was put at imminent danger of harm when he let an adult who's a stranger to him in his home. So in this case, this child is definitely neglected under New York State law. Let's do another one. John, age 12, left his home without his mother's permission and did not return by his 6 p.m. curfew. When John got home at 7 p.m., his mother repeatedly struck him with a belt. John has belt-shaped marks on his buttocks and back. Is this neglect? Yes, it is. The minimum degree of care in New York State requires that parents not use excessive corporal punishment. And as we discussed in part 1, parents are allowed to use physical punishment on their children. That is allowable under New York State law. However, our law also states that physical punishment cannot be excessive. And hitting a 12-year-old child with a belt with such force that they have belt-shaped marks on various places of their body is excessive corporal punishment. And therefore, John has been neglected. His mother failed to provide the minimum degree of care, and that she inflicted excessive corporal punishment. What is the harm? Well, he was physically harmed. Kayla is 4 years old and lives with her guardian. Kayla has learned bad words at preschool and calling her guardian a bitch. Last time Kayla said it, the guardian slapped her across the face and put soap in her mouth. Is this neglect? It is. Now, we just talked about how parents in New York State are allowed to use physical punishment on their children, and certain slapping a child and putting soap in their mouth would constitute a physical punishment. The reason this is excessive is why. What factors in this case make you think this is excessive? Well, Kayla's only 4 years old, right? So slapping her across the face is certainly inappropriate on a child that young. And putting soap in a child's mouth who's 4 years old, or really any age, is really sketchy. It can be really dangerous to put an object in a child's mouth. If the child chokes or swallows that object, that can be very dangerous to the child. So certainly slapping a 4-year-old child across the face and shoving soap in her mouth when she's only 4 years old would certainly constitute neglect. This punishment is also very disproportionate. You remember that's one of the factors we talked about. Kayla's only 4 years old. All young children experiment with bad language. That's how they learn what is allowed and what is not allowed to say, by saying it at the wrong time and to the wrong person. So certainly Kayla needs to be instructed or disciplined, because that is a bad word a 4-year-old should not be saying. However, slapping her across the face and putting soap in her mouth is excessive under the law. Jordan is 10 years old and occasionally wets the bed at night. When his father discovered he'd wet the bed yet again, he made the child wear a large sign that said, "I'm a baby and I still wet the bed." Jordan's father put the sign around Jordan's neck so it covered his entire chest. Jordan was then forced to walk up and down the street in front of his house for 30 minutes wearing the sign. Is this neglect? Well, let's break this up a little bit. What's the minimum degree of care? Well, the minimum degree of care says there can be no excessive corporal punishment. And making a child wear a sign is a physical punishment, right? You're doing something to the child's body. So is what was done here excessive? And I would say yes, this is neglect, because this punishment is excessive and it's not meant to educate Jordan. Jordan's not going to learn anything about not wetting the bed by having to be, forcing to wear this sign in public. He's only going to be embarrassed. And Jordan's father is clearly trying to humiliate the child. So this physical punishment is not being done to educate the child. It's being done to humiliate the child. And even a child 10 years old can certainly, drink too much water before bed and have an accident. So it's really not fair to physically punish the child for this at all. Certainly, there could be disciplinary measures like not being able to have snacks and drinks and water late at night would certainly be a good way to begin with this child. Or if this child has some sort of medical issue that's causing him to wet the bed, certainly that could be addressed. But forcing the child to wear a sign up and down his house in front of the yard for half an hour is purely just designed to humiliate the child. It's not instructive. Therefore, this is neglect. So I hope those examples have helped. Again, it's really important that you fully understand how the definition of neglect is applied to cases, not only for your own knowledge, but it will appear on a quiz and your final exam. So if you have any questions about the definition of neglect or how it's applied, please let me know. I'm happy to help you with that. So for the rest of Module 9, you do have an article to read. It's about 8 types of parents. There's a short media item on spanking. That's a required item. And then just something for you to look at. I found a job posting for the statewide Central Register of Child Abuse and Maltreatment, just so you can get an idea of the qualifications for that job and what it pays. You have a project due this week by Monday night, and you also have an opportunity for extra credit, also due by Monday night. Here's an important caveat to remember. You have no quiz this week. There's no quiz this week for Module 9. However, your quiz next week in Module 10 is going to cover material from both modules. So you will be tested on the material from Module 9 and 10 together next week. And because your lecture was quite a bit longer this week, you have no textbook assignment. Thank you for listening. And as always, if you have any questions or need any help, please let me know.